So what happens if you're released to work with restrictions and the employer decides that they want to offer you work within the restrictions? What can you do? And what happens if the employer offers you work and you have no restrictions, but you don't think you can do your job? What happens? Today we're going to talk about that here at Kaplan Morrell. Hi, my name is Britt Morrell, and I'm an attorney working with injured and disabled workers in Colorado since 1995. And we've been helping injured workers get the benefits that they deserve, and we would love to be able to help you. Today, we're talking about what happens if you've been offered work within your restrictions, and what should you do, and what are the implications if you don't go to work. And with that, let's dive into it. If you are injured on the job you're treating, the chances are the doctor is going to give you some restrictions, limitations on things that you can't do. For example, you might not be able to lift more than 20 pounds. You might not be able to bend. You may be able to do things only occasionally or rarely or not at all. So it's really important for you to understand what your restrictions are when you have them. Now, then the employer may choose to offer you what's called modified duty, okay? And that's work within the restrictions, supposedly, that the employer is offering you. What happens? What are your obligations? Okay, so there are two ways that you can be offered modified work from your employer. One is just kind of informally, like, hey, Jim, come on into work. We've got some work for you. It's light duty work, etc. And then there's another way, which is formally, and that's a written job offer that is sent to you by certified mail. It can be a little weird to get something in certified mail with a job offer. It may feel kind of like, wow, they're kind of getting all serious on me, but there's some reasons for that. So if the employer offers you work within your restrictions, supposedly, and it's verbally, my general recommendation is go try it out. Go talk with the employer. Go see if it's something that you can do or not. And if there are certain things you can do, say so. And if there are certain things you can do, but only do it for a limited amount of time, say so. And if there's some things in there that you can't do at all, then I would say that as well. But always do it. But if you don't show up, don't do it, here's what could happen. The employer could, at that time, terminate you for not coming to work, and then the insurance company may decide to try to shut off your lost wage benefits, called temporary disability benefits, because you are now off work because you turned down a job. However, the insurance company would have to file a petition, a piece of paper, asking to suspend your benefits, your lost wage benefits. And if you object to that, then the insurance company would have to go to court and prove to a judge that you voluntarily terminated the job, okay? So that's what happens if it's a verbal offer. Okay. On the other hand, if you get an offer of modified duty that's in writing, that was sent to you by certified mail, and it lists out the job duty, it lists out the physical requirements, and it's signed by your doctor, that's the other thing, then if you don't show up for that job, and there's a certain amount of time that they have to give you, in other words, they can't have this letter descend on you on Tuesday and you have to show up to work on Wednesday. There's typically a time period that you have to be able to respond to it. But it should say what your job duties are, what the limitations are, what you'll get paid, how many hours, and it should have the signature of your treating physician. If you don't show up for that, what's going to happen is the insurance company doesn't have to ask to suspend your benefits. They can do it immediately. They can file another, what's called a general admission of liability, either shutting off your pay entirely or shutting off the lost wages you would have earned had you gone back to work. So it's really important for you to respond to these modified job offers. And if you're represented by an attorney, you should quickly talk to your attorney about what's going on and how do I handle that, because often people have concerns which are reasonable, but the law takes care of. For example, maybe you were working and you are making $25 an hour, and now they're offering you a modified job where you only make $16 an hour. And I've had some clients go, oh, I'm not going to do that because how do they expect me to survive on that? And my response is, yes, you'll get the $16, but the insurance company has to make up the lost wages, the difference between what you used to make and what you are making now at this modified job offer. So go do it. Try it out. See, and don't worry, whatever you don't make compared to what you used to make, you're going to still get 2/3 of the lost wages for that. Okay. Sometimes there's some issues about the modified job offer because, for example, you used to be working days and now they want you to work nights, or you used to be working nights and now they want you to have days. We've also seen job offers where literally the place of employment was 150 miles away because this guy used to work in construction, so he'd kind of go around, but now they want him at the main office. It's 150 miles away. He doesn't have any transportation to get there. So there's always some arguments about whether or not the job offer is reasonable, but the worst thing that you can do is just ignore it. The worst thing that you can do is just throw it away, not respond to it, because it deprives you and your attorney the opportunity to figure out these issues, to raise these reasonable concerns before and try to get them resolved before, so you're not suddenly finding yourself injured, restricted, and not getting any wage loss. That's what we're trying to avoid. As you can tell, these things can get very fact specific, very detailed, and for that reason, we recommend strongly that you have someone walk with you in this process who runs this maze every day. The insurance company, their adjusters, they already have attorneys on staff, on call to help them navigate and run this maze we call workers' compensation in Colorado every day. And if it's a race between you and them, and they run this maze every day, you know who's going to win. They will. And that's why you need somebody like Kaplan Morrell in your corner to be able to help you navigate this maze and make sure you get the benefits that you deserve. There's so many ways to reach out to us. You can call us at 970-356-9898. You can text us at 970-356-9898. You can contact us via WhatsApp, +1 970-356-9898. You can go to our website at www.kaplanmorrell.com and reach out to us that way. We serve Colorado no matter where you are. If you've got a smartphone in your pocket, then we are with you because we can chat with you face-to-face. We can send you documents, receive documents, no matter where you are in Colorado, we're able to help you. And with that, thank you so much for spending part of your day with us. And remember, we only charge a contingency fee, which means we only get paid if we get you benefits. And with that, you have a great and safe day. Thank you. Bye.